Orders of the day.
Order of the day number 1. University of Tasmania Protection of Land Bill 2025, Bill number 58 of 2025. Further consideration of bill in committee of the council, clause 3.
Yeah.
Clause 3, proposed amendment.
Honourable Member for Hobart, you're on your feet for your first call.
Yeah, thank you, Madam Chair. I won't speak for much longer. Simply to say this is an important amendment because, as all honourable members will know, a 99-year lease is as good as selling an asset, and in this case, that asset is public land that is vested in our only university, and there's enough that's objectionable about this bill in its rezoning and the potential loss of excellent facilities north of Churchill Avenue. So I hope that honourable members will see that this is an important amendment. It provides Parliament with an opportunity for oversight of a lease that has a provision of more than 30 years in its term. It's kind of in some ways with this legislation trying to make the best of what the Greens certainly believe is not a good situation. But that oversight over public land and the proposed long-term leasing as good as a sale of that land is something that certainly the Greens believe is important and necessary. So I hope other honourable members will support the amendment.
Question is the amendment to be agreed to. Those that Honourable Minister.
Oh, sorry.
Oh, sorry, I didn't see the member for McIntyre. Honourable Member for McIntyre.
Thank you. Just a question to the honourable member who has proposed the amendment. I'm just trying to reconcile if you built a housing, some sort of development that was going to, be housing, how 30 years would fit with borrowing money for something like that. So I'm just trying to reconcile that in my mind. Was there any other option considered? I understand what you're saying about a 99-year lease, and it does appear to be a very long time. But I'm just thinking 30 years doesn't seem to me to be a long time to have that, I suppose, what you would call security for if you were going to borrow money to provide some significant infrastructure. So I just hope that you might address your mind to that when you next get to the lectern. Thank you, Madam Chair.
Question is the amendment be agreed to. The Honourable Minister.
Thank you very much, Madam Chair. The government does not support the proposed amendment to expand the definition of dispose to include leases of over 30 years. The university is encouraged to enter partnerships in the establishment and operation of the STEM precinct. It has always been an aspiration that industry engage with the precinct, and leases may be required to justify capital investment in that partnership. The university already has leases on facilities at the Sandy Bay campus that are over 30 years, and an example of that is with organisations such as the CSIRO. The objective of the bill to ensure that the land required for the delivery of the university's activities in Sandy Bay stays in public hands for future generation, and prohibiting the leases over 99 years without parliamentary approval delivers on this objective.
The honourable member for Hobart.
Sorry, that's a quite disappointing answer for the Leader for Government, because this amendment does not propose to prohibit the university entering into leases of more than 30 years. What it says is that if the university wants to engage in a lease of 30 years or more, then Parliament should have an oversight role. And in fact, it still wouldn't preclude, for example, if the university felt so inclined, them having a potentially 200-year lease. It's not the length of the lease that's the issue here, it's the trigger for oversight. And I think it's a very reasonable amendment, because in the end we're still talking about public land held in trust by a public institution.
The question is the amendment be agreed to. The honourable member for Nelson.
Thank you, Madam Chair, and thank you, members, for questions. I'll just first address the member for McIntyre's query that she put to me. So, as the member for Hobart has just said, what I'm proposing prohibits nothing. So, if the university were to be leasing land for example, a housing development, as you indicated, that's a pretty serious long-term effort that is disposing of land pretty much permanently. So all this would do is, if they're going to do a long lease in order to do that, it would just have to come through Parliament. That's all that this is requiring, that any lease over 30 years triggers that requirement in this bill for vested land, the disposal of vested land, to come via Parliament with the motion that is laid on the table. So it doesn't stop anything happening, it just brings the oversight threshold down from 99 years, which is an incredibly long multi-generational time, down to 30 years. And that just means there's accountability in a public way through Parliament for that. I'm very interested in the Minister specifying that the CSIRO lease is already over 30 years, because if she's referring to the CSIRO facilities above Churchill Avenue, of course, that's in the rezoned land proposed under this bill. So it has nothing to do with what I'm proposing here, if that's the existing lease that she's talking about. If there are existing leases in what this bill prescribes to be vested land below Churchill Avenue, then absolutely identify them. I would presume that any existing ones are not captured by this, the way that other existing arrangements aren't captured by what's in this bill. So, again, there's absolutely nothing that isn't reasonable about asking for leases over 30 years to come via the oversight mechanism of this Parliament under this bill. Most commercial or industry partnerships that were involving leasing areas of land, 30 years is an incredibly long time for any commercial venture to enter into a lease, or for any particular industry partnership to enter into a lease. It's a very long time indeed. I'd be surprised if there were many that were proposed to be above that, and if there were, there's absolutely no harm in it coming through this Parliament for that oversight function. So I'd ask members to see this as a very reasonable, very aligned with the intent of this bill, and very much making sure that Parliament has the role that this bill with this title, University of Tasmania Protection of Land Bill, that at least in some instances lives up to that title, that we have an oversight role for this Parliament.
The honourable member for McIntyre.
Thank you, and appreciate the honourable member addressing her mind to my question. Just to follow on from that, then how does someone have the certainty of they've had a lease for 30 years, and then it comes back to the Parliament, and we have no idea what this Parliament might look like in 30 years.
That's not what it says. That's not what it says.
Well, it says, I thought I understood you to say that it would come back to the Parliament for oversight.
No. If the lease is for more than 30 years, it has to, so if a proposed...
Order.
If they're proposing to enter a lease of more than 30
years,
that has to come through here before they enter that lease. Yeah. So it's not at the end of 30 years, it's at the start.
It's the start of 30 years.
If it's more than 30 years, that's when it comes through.
Okay, and so then my follow-up question is, was 30 years chosen because you had, in your mind, thought that that was a reasonable length of time, and then by the explanation you just provided as well?
Well, I did say in my opening remarks, when I have my final say on the bill, because I don't want to jump up, but when I do...
I just urge other members who may have questions for the member, if you haven't got any more, Member for McIntyre,
Thank you. I appreciate the clarification.
The member will be on her third call. The question is the amendment be agreed to. The Honourable Minister.
Thank you very much, Madam Chair. Look, I think it's a little bit unfair for the Honourable Member for Nelson to say they just come to Parliament. It's not an easy thing to just come to Parliament. There's quite a process around that, as there should be. So, you know, we don't want to be in a position where we're creating uncertainty for opportunities. So a lease of 99 years or more is widely recognised as being in practical terms equivalent to a permanent transfer of control, and it is therefore appropriate that such arrangements are treated in the same way as a sale. The university already uses long-term leases in some circumstances to support partnerships and shared facilities, and the bill preserves this flexibility for leases under 99 years. The 99-year benchmark is also consistent with established Tasmanian land law. Under the Crown Lands Act 1976, 99 years is the maximum lease term that can be granted. The bill adopts that same threshold as a clear and well understood point at which Parliament scrutiny should apply. This goes to the core intent of the bill, to ensure there is no permanent or near permanent loss of control of this publicly gifted land without transparency and the approval of Parliament. Setting a lower threshold, such as 40 or 50 years, would create unnecessary barriers to investment and development, particularly in the context of the inner residential zoning and the delivering of housing and the STEM precinct. This bill is designed to strike a balance between protecting the public interest in this land and enabling the university to enter into long-term commercial partnerships and development arrangements, while ensuring that any arrangements which effectively gives away long-term control of the land is subject to parliamentary oversight. And again, I would ask members to not support the amendment.
The Honourable Member for Elwick.
Thank you, Madam Chair. I'm happy to support the amendments as put forward, and listening to the Minister's response there, I find it difficult to understand the logic whereby if the intent around the bill is to ensure certainty around non-permanent, ensure parliamentary oversight of non-permanent or near-permanent use of the land, which is what I heard the Minister say is the intent of the bill, ensure parliamentary oversight over
permanent or near-permanent.
Permanent or near-permanent, thank you, use of the land, then certainly 99 plus years is equivalent to permanent or near-permanent use of the land. And so I'm feeling like the statements are a little bit contradictory there. I don't know if the Minister has another call or not, but
The Minister's got as many calls as she needs.
Somewhat contradictory in that sort of statement of the intent of the bill versus how you described 99 plus year terms being considered in the property market, if you like, or the use of land market. Sorry, I'm not being very articulate.
The question is the clause as the amendment be agreed to. The Honourable Member for Hobart, third call.
Thank you, Madam Chair. My laptop's just died, so I can't go into the Nature Conservation Act and have a look. And perhaps the Minister can clarify this for me, but I thought the provision in the Nature Conservation Act effectively prohibited any lease of more than 99 years, and if I'm wrong on that one, please correct me. So it's very different because this is the threshold. This is the threshold for oversight, which is not about a restriction, and in fact it is not any restriction. And members should be, members should be a bit cautious about accepting that we abrogate our oversight responsibility on the basis of barriers to investment and redevelopment. It's not like we're talking about any type of land or land of any private tenure, for example. We're talking here about public land that belongs to the people of Tasmania. And so to use the argument that allowing Parliament to have, through a disallowable instrument, some oversight of any lease over 30 years, to use the argument that that may be a barrier to private investment and redevelopment, I think is quite cynical given the nature and the tenure of this land. And I'm not sure, and perhaps the Minister, and I understand the Minister is getting some advice on this, but I don't know that the comparison with the Nature Conservation Act is relevant in this case. And if the Minister could clarify that, that would be good. But, you know, Parliament has a responsibility in relation to UTAS, its governance, its direction and how it disposes of public assets. And that's what this amendment is all about. It's not about stopping 99-year leases or 200-year leases. It's about making sure we can have a look when the university decides it's going to dispose of land via a lease of over 30 years, which is, you know, a third of our lifetimes if we're lucky. It's not a short period of time, and any investor who's serious about investment in this space will see that as a quite reasonable threshold, I would have thought, because which Parliament, if given a good opportunity through a lease that UTAS is negotiating in good faith, if this legislation passes, which it seems to will be, which Parliament would go, well, we don't want to see that project there because, you know, we don't support housing, for example, on that site. So I hope that the Minister can explain why we should regard investment and redevelopment barriers as a reason to abrogate our responsibility for oversight.
The question is, the amendment be agreed to? Honourable Minister.
Thank you very much. Honourable Member, we've quickly jumped online. We can't see, with the time that we've had, any reference in the Nature Conservation Act to the 99-year lease. I did say in my comments that the 99-year benchmark is also consistent with established Tasmanian land law under the Crown Lands Act of 76. The 99 years is the maximum lease term that can be granted, and the bill adopts that same threshold as a clear and well understood point at which parliamentary scrutiny could apply.
False equivalent.
Order.
Also, the 99 years is the established threshold for treating a lease as similar to sale, and so lowering the threshold to 30 years is a significant change.
The Honourable Member for Rumney.
Thank you, Madam Chair. Just a brief contribution on the amendment. I guess the point I was going to make is similar to what the Minister has just said, in that I guess I'm inclined at this stage not to support the amendment because the definition we're talking about here is disposal, and a 99 plus year lease is, I guess, what is generally accepted as being the equivalent of a disposal in the same way as a sell or selling the land or a more permanent disposal. So my question for the member, and I apologise if I've missed this in earlier contributions, Member for Nelson, is why 30 years? Why you've landed on 30 years? And is that based on advice or consultation that you've had with anyone?
I'll repeat my opening comments when I get up for my third call on that.
Yeah, and specifically whether you've had any consultation with the university or anyone who might be looking to, who might operate in this space around long-term investments, around that 30-year figure.
So I'm going to take my third call.
She's taking a third call.
I just want to be clear that if anyone's got any other questions of Member Nelson, they need to get up and pose them. Otherwise, I'll give the call to Member Nelson. Member Nelson.
Thank you, Madam Chair, on that, and thanks to the members for the questions. And so I'll just run through, because the member for McIntyre and the member for Rumney both asked about the 30-year number. And so as I said when I was first putting this amendment, a couple of things about that. One is that it is a length of time that aligns with ordinary commercial practice for major leases and it's consistent. The other thing it's consistent with that's relevant here is that in other jurisdictions under their university acts, when they have a constraint on universities selling gifted land, which most of them do, and that's one of the reasons, just to remind people, that when we had the UTAS inquiry and looked at governance matters and the University of Tasmania Act, one of the recommendations of the inquiry of this place was that this sort of constraint be put back into the Act. In 92 it was taken out, it had been there prior to that, so this was part of that inquiry recommendation, was that we should re-legislate a similar parliamentary oversight mechanism such as this. And when we look to other jurisdictions, it's typically about 20 years in other jurisdictions. So it's actually more generous, like a longer term than is in other jurisdictions' university acts that constrain or impose oversight at a 20-year lease level typically. So there's that. 30 years still provides ample security for genuine campus-related commercial activities. So if the university's entering into commercial leases with people on that vested land area for whether it's research or services or other industry sorts of partnerships, 30 years is a very long lease to enter into. So there's nothing that is particularly constraining about that. Most leases are going to be less than 30 years. If it's more than 30 years, it's likely to be something fairly permanent. And the intent of this bill is to have parliamentary oversight operate on things that are permanent changes to what we're defining as vested land under this bill. And as the point has been made time and again, this isn't a constraint. There's no equivalence to looking at what other legislation says must be maximum leases, because this isn't about setting a maximum lease period. This is about setting the point at which parliamentary oversight is triggered by this bill. So the university will be perfectly at liberty to put forward proposals to have longer lease periods than 30 years. It just means that if it is a longer lease period that's more than 30 years, it would come and be a motion laid on the table of this place and the other place, and Parliament would have that as a disallowable instrument. And I'd also remind members, it's really hard to disallow something in this place. Hardly ever happens, right? It's actually, in lots of ways, a formality of parliamentary oversight. But what it does mean is, if something dramatically inappropriate was being proposed, we have the backstop of parliamentary oversight. If it was something that the majority of people in this place or the other place could be convinced was dramatically inappropriate, there would be a block on it available via Parliament. And that's the only accountability to the Tasmanian community that the university has, because largely they're not accountable to the Tasmanian community at all.
Not accountable to anyone, really.
Indeed. So I'd invite members to see this as not a serious constraint on the university. Yes, they'd have to bring it as a motion, or have the Minister on their behalf bring it as a motion to this place. I'm sorry, but if they're offering more than a 30-year lease, they would absolutely have put time and thought into that and have it as a proposal that could readily be presented to this place via a motion and laid on the table for us to have a look at, and just have that opportunity for parliamentary oversight. So it aligns with what would be considered long commercial leases. It aligns with other states' university acts and the constraints they put on universities disposing of gifted land, and it's a reasonable amount of time to impose a level of oversight rather than impose any maximum whatsoever about what can actually be done, which this does not do that. So please invite members to consider this as a way for this place to do its job well on behalf of the Tasmanian people in regards to the intent of this bill.
The question is the amendment be agreed to. Those, Honourable Minister.
Yeah, thank you very much. Look, just to, reiterate, lowering the threshold to 30 years is a significant change. It is a significant change. And this bill is all about trying to strike that balance between protecting the public interest in this particular piece of land while also enabling the university to enter into those long-term commercial partnerships and development arrangements. And, partnerships of this sort would require quite significant capital investment, and we certainly want to be ensuring that any arrangement which effectively gives away long-term control of the land is subject to parliamentary oversight. So, again, I just urge members not to support the amendment.
The question is the amendment be agreed. Member for Elwick.
Well, the way I read this is if the intent is really protection for the Tasmanian people, if that genuinely is the intent of the government, I can't understand why it takes issue with this, because the university is no doubt going to enter into a lease for the term that whatever term means it doesn't have to come back to Parliament. That would be the thing you would do if you wanted to avoid parliamentary oversight. It is the way I read it. So if the government is genuine about it being protecting Tasmanians' interests here, what's wrong, or what's the risk, what's the burden to the university of making it 30 years, and why does the government have a problem with that? I just cannot understand the government's logic here about if it genuinely is about protecting Tasmanians' interests and genuinely about protecting land that is, gifted for educational purposes, why not bring it back to the Parliament? What's the risk? What does the government have to lose here, or the Tasmanian people have to lose? It's in their interests.
Honourable Leader.
Yeah, thank you very much, and I thank the honourable member for her comments. Again, can I just reiterate that the 99-year benchmark is consistent with established Tasmanian land law. So under the Crown's Land Act of 1976, 99 years is the maximum lease term that can be granted. And just because we had the, what's the bill called, the Nature Conservation Bill up, it also states in there, sorry, can you go back up to there? No Crown land shall be leased for a period exceeding 99 years. So it is a little bit about consistency as well. They're two, Tasmanian Land Acts that also have this same setup with the 99 years. And, as I said earlier, it's about, if we do lower that threshold, 40, 50 years, it does create unnecessary barriers to investment and to development, and we want to be setting our university up for opportunities.
This is simply not a comparable example that has been given. This is not Crown land. It's not subject to any of the processes. Not subject to any of the processes that are to be followed in terms of the sale of Crown land, if the government would actually follow those processes. Anyway, but I'm not convinced by the minister's response. This bill itself, it's not a typical circumstance. We are legislating for an extraordinary circumstance here. And the more protections that we can put in place here, the better, in my point of view anyway. So I hope honourable members will support this amendment.
The question is the amendment be agreed to. Those that opinion say aye.
Aye.
Against no.
No.
Divide.
Sorry, I haven't called it yet. I'll just try to work out who got it. I think the noes have it.
Divide, please.
Division required, ring the bells. Just need. All members being present, so order to stop the bells and lock the doors. The question is that the amendment be agreed to. Those with that opinion say aye.
Aye.
Against no?
No.
The committee will divide. The ayes will pass to the right of the chair and the noes to the left. Appoint the honourable member for Rumney, teller for the noes. Honourable member for Huon, teller for the ayes.
Thank you.
Sorry.
7.
Order. The result of the division is ayes 7 and noes 7. Therefore, as the members have been unable to convince the majority, the motion passes in the negative. The members please resume their seats. Yeah, that can come back. Oh, sorry. The question is the clause as read stand part of the bill. Those that opinion say aye.
Aye.
Against no?
No.
I think the ayes have it.
Clause 4.
Question, Honourable Member Nelson.
I'll move all this set of amendments, Madam Chair, because they go together. So if I move them all and then put the argument to them all, if that's all right with you? Yeah, they are. So go through them all. Clause 4, First Amendment, page 5, subclause 2, paragraph A, after subparagraph I. I'm just going to get to that spot myself. All right, subparagraph 1. Insert the following subparagraph. X must provide to the Minister with the request under subparagraph 1 a report in accordance with subsection XX and Second Amendment, same page, same subclause, paragraph B, after is to table B, leave out motion, insert instead motion and the report under paragraph AX provided to the Minister with the motion. Third Amendment, page 6, after subclause 2, insert the following subsection, XX. A report to be provided by the University under subsection 2AX in respect of the proposed disposal of vested land under this section is to include A, the reasons why the University intends to dispose of the land, and B, if known, the purpose for which the land is intended to be used after the University has disposed of the land, and C, if the intended use of the land after its disposal is not known at the time the report is prepared, a statement to that effect, and D, the characteristics and qualities of the land, including but not limited to 1, the geological, biodiversity and topographical characteristics of the land, and 2, a list of all existing structures on the land, and 3, details of any consultation undertaken by the University in respect of the proposed disposal of the land, including but not limited to consultation with statutory authorities and planning authorities. So members, that's, and I realise, a long inclusion. Here's the intention of that. Clause 4 of the bill as it currently stands is about what happens when the University wants to dispose of a piece of land that is vested land under the Act. It describes the process that the University has to go through in conjunction with the Minister to bring it to Parliament for consideration as a motion laid on the table. The way it's currently drafted in the bill, the motion that relates to the disposal of that vested land has to requires very little detail to be provided to the Parliament when Parliament might consider that motion that's laid on the table of the Parliament. So, for example, if we look at the clause as it's currently drafted, clause 4, part 1 just says that the University can't dispose of things of vested land unless it's come through the Parliament. Part 2 is about if the University does wish to dispose of all or any part of the vested land, the University must do these things. It has to make the request to the Minister to table a motion in respect to the disposal of the land. It has to provide the Minister with a draft motion that meets the requirements of subsection 4, which we'll get to in a minute. And if the Minister is satisfied that the motion provided meets the requirements of subsection 4, the Minister tables the motion in each House and it's disallowable. And that's described in part 3 of that clause. Part 4 is about what's required to be provided as part of this motion for the Parliament to consider if this process is triggered and is underway. So it's part 4 of the clause says a motion to approve the disposal of vested land that is to be tabled under subsection 3, A, must include a clear description or plan of the area of vested land that the University proposes to dispose of, and 2, the disposal of the land is, if the disposal of the land is by the lease, the details of the term of the lease, and 3, the details of the amount of payment or consideration or any other benefit the University is to receive if the disposal is approved. So I have no problem with 2 and 3, which is if there's a lease involved, we need to see the lease. If there's information about the amount that they're going to get for it, we should see that. I have no problem with that. My problem is with part 4A1 here. All the information that we would be required to be provided with as a Parliament to consider this sort of motion to dispose of vested land. And remember, going back to the start of clause 4, this could actually relate to the entire parcel of vested land. So if the University wishes to dispose of all or any part of vested land. So what we're talking about here is could be a motion coming to this place that proposes to dispose of all of the Sandy Bay campus land below Churchill Ave, which is what this bill says is vested land. So with that in mind, if a proposal came to us as a motion to dispose of all of that land, for example, as it could, all we'd need to be given is a clear description. So it would have to say the land in the relevant folio below Churchill Ave. That's a clear description of that land. Or plan of the area of the vested land. So a description or a plan of the area of vested land. All it needs to do is describe what the land is. That could be as absolutely simplistic as Sharpie pen drawings on a fuzzy aerial photo, which is what this bill has with the rezoning. in Schedule 2 of this bill. We could get something that is a fuzzy aerial picture of the whole of the Sandy Bay campus under Churchill Ave with a Sharpie line drawn around it and meet the requirement of this Clause 4 if the university was proposing to dispose of the whole of that area, the vested land described in this bill. That's a worst case scenario, right? I accept that. I've just painted for you the worst case scenario. But the bill says what we should expect to see, and all we should expect to see is apparently the area, let me get back to the wording, a clear description or plan of the area of the vested land. That's it. So what my amendment does is it outlines with a little bit more detail some minimum requirements of the information that should accompany that motion if it were to come to us for any disposal of an area of vested land, whether that's a part of it or all of it or whatever it might be in the future. What should we as a parliament expect to see information-wise? And the amendment says there should be a report that accompanies it, and that report should have included in it the following things, which are in the amendment here. A rationale for it, so the reasons why the university is intending to dispose of it. I think the university should have to say on what basis they need to sell or dispose of the land that's there. B is about, if known, the purpose for which it's intended to be used after the university's disposed of it. Pretty reasonable. If they don't know that, then a statement that says they don't know what it's going to be used for when they dispose of it, but that's just a clear statement one way or the other. D is important, I think, because we've just seen this bill ask us to rezone land with absolutely none of the normal information provided through a planning process. This is a very light touch to try to make sure we're never treated like a rubber stamp in that way ever again if we did have a motion come to us to consider that related to disposing of vested land. So the report that had to accompany that motion, according to my amendment, would have to include information about the characteristics and qualities of the land that's in the proposal, including these things: the geological, biodiversity and topographical characteristics. So again, some basic information. A list of all existing structures on the land. Again, it's just basic information, so we're really clearly understanding what we're being asked to consider. The third thing is details of any consultation that's been undertaken by the university in respect of the proposed disposal of the land, including but not limited to consultation with statutory authorities and planning authorities. So that means maybe there's been consultation with the Hobart City Council, maybe there's been consultation with Taswater, maybe there's been consultation with other sorts of statutory or planning authorities. That's it. It's just requiring a report that outlines those very basic things that I would think this Parliament, since under this bill, Parliament's being given an oversight role to consider any disposal of vested, meaning that gifted land that's defined as vested under this bill. Parliament's oversight role surely requires us to expect there be some very basic information provided with a motion to that effect. So far in the bill, as drafted, there is no requirement for that basic information, none. You could meet the requirements of this bill with a fuzzy aerial map with a Sharpie line drawn around a bit of land on it. And it could be the whole campus below Churchill Ave. This is not a dramatic ask. This is a bare minimum ask of accountability to add into this bill in anticipation of a time in the future that this Parliament might be invoked to do the oversight role the bill sets up. And I would hate to think that we would leave the bill as it is without at least this minimum requirement, because to me that would say we are setting this chamber up and this Parliament up to be a rubber stamp down the track if we don't at least put some very minimal requirements in there for what we would expect to see in terms of information alongside a motion to dispose of vested land. So I hope members have heard that rationale for the amendment. Again, it's not dramatic. It's a very basic, responsible proposal to include. It doesn't change any intent about this bill at all. It's aligned with the fundamental intent of the bill, which was to give Parliament an oversight role. So, again, there would be no reason for a responsible government, or in fact for the university to have any objection to this, because they should be able to explain to us and should be expected to explain to us why they're bringing a motion down the track under this legislation for consideration by this parliament. If the university wasn't entirely happy to do that, we would have serious questions of the university, I would think. Surely the university would say to the government, we welcome this amendment. Any responsible governance mechanisms of the university would say, we welcome being expected to provide this very minimal amount of information if in the future we were to propose to dispose of any of this vested land, in fact, perhaps all of this vested land. So I strongly request members really think about supporting this amendment as an important part of our role here with this bill.
Wishes the amendment be agreed to. The Honourable Member for Hobart.
Thank you, Madam Chair. This amendment, in some ways, although it adds more words and provisions, tightens up the intent, I think, of Clause 4 in the bill. And when you look at the matters to be provided to government and to be included in that notice to Parliament through the disallowable instrument that are proposed in this amendment, you would think that this information is kind of in some ways the bare minimum of what the university should provide to the Parliament should it wish to dispose of any of the public land which is currently vested with it. So this is not like the previous amendment where not a majority of members were persuaded that you needed to have some tightening up around lease oversight. This is simply enabling the Parliament, when that disallowable instrument comes to the Parliament, to have really what's quite straightforward and basic information from the university about the purpose for which the land is intended to be used, the characteristics and qualities of the land, including biodiversity and topographical characteristics, all the structures on the land. These are the basics. And in some ways, what it might do, should Council accept this amendment, and should the moment come when we're dealing with a disallowable instrument in this regard, it might actually save some time, because there'll be real clarity in the instrument that comes to the Parliament for examination. So, notwithstanding the previous vote, I hope that honourable members see that this is a very, very sensible and I'd argue necessary inclusion into this bill, in order to protect the public interest, but in order also to have maximum clarity and transparency about the nature of the land that UTAS wishes to dispose of.
Wishes the amendments be agreed to. The Honourable Minister.
Thank you very much, Madam Chair. The government does not support the honourable member's amendment and considers that it is over-prescriptive and unnecessary. A motion to dispose of vested land is a disallowable instrument, which means the University of Tasmania will need to provide adequate information that would satisfy members that the motion should not be disallowed. Now, the nature of the information required, that would actually depend on the circumstances of the proposed disposal of land, and members at that time would be able to request any information from the university that they need to be satisfied that the motion should not be disallowed. So a couple of other things I would like to raise. The information relevant to a disposal of land would actually depend on what was actually being proposed. So this House, I feel, well, I'm concerned this amendment is actually trying to preempt what is required to convince members to not disallow a motion. So obviously the university would be putting forward as much information as required to ensure that members were satisfied and didn't move for a disallowance. Now, I do just want to clear up, and I understand the example that the Honourable Member for Nelson put forward about the fuzzy map, but I do think, in Clause 4A1, it does clearly state that a motion to approve the disposal of vested land that is to be tabled under subsection 3 must include a clear description or plan of the area of vested land that the university proposes to dispose of. And I think that, the university would be putting their absolute best foot forward and ensuring whatever information members required, that they would put that forward to ensure that it wasn't, disallowed. So we're not going to be supporting the amendment. We do believe that the bill covers off on what is required, and also that, it is in the university's best interest to provide any information that would be required at the time to convince the Parliament to support it.
So they'd have no problem with
The
this.
question is the amendment be agreed to. Member for McIntyre.
Thank you, Madam Chair. A question to the Honourable Minister. Can we have some indication of what the government considers is a clear description? The Honourable Member proposing the amendment gave out just the folio number of where it was situated, perhaps you meant, and the address.
Well, I wonder if a clear description is what we've got in here about the rezoned land.
Order.
So I'm just looking for, because you've put on the record that the university would be putting their best foot forward, but I'm interested in what a clear description might look like if it's not what has been proposed in the amendment, or is that exactly what you would be expecting?
Just seek some advice, Madam Chair.
Honourable Minister.
Thank you very much, Madam Chair. In response to the member for McIntyre, the expectation would be a plan that has been mapped by an appropriate qualified surveyor. So when you look at Clause 4 and you have there, that it must include a clear description or plan of the area of vested land that the university proposes to dispose of, that expectation would be that plan had been mapped by an appropriately qualified surveyor.
Question is the amendment be agreed to. The member for McIntyre.
Appreciate that, but it does say a clear description or plan. So if it's just a plan, and we've seen the fuzzy plan that's been referred to, so I'm looking for some more detail around a clear description. So, and I think it'd be useful to have that on the record.
This is a question on the clause rather than a question.
Honourable Minister.
Thank you very much, Madam Chair. So when we talk about a clear description or a plan, the description, for example, could be relating to an identifiable building. So it could be a description of a building. Does that answer your question, Honourable Member? Or I think you've got another call.
I might use it.
Yeah.
Others might have.
The question is the amendment be agreed to. Member for Mersey.
Yeah, look, thank you, and I appreciate both the amendment and the response from the Minister. But when I look at the amendment, if I was sitting here and this came to Parliament, that gives a pretty good blueprint about what I would expect to receive for me to make an assessment on what's happening. This one over here just says a plan or a clear description.
Of the area.
So that of the area, so that big brown building over there, covered by trees, surrounded by trees, where this talks about the reason, the purpose, the intended use of the land. It gives, and I think with all due respect, the university would have all that anyway. You wouldn't go into this arrangement if you didn't have that information right there. So I think the I think the government is being very guarded on this, and there's no reason for it to be. That's the university's core business. If they can't do that, then they shouldn't be looking at getting a STEM facility anywhere if they can't provide us with that information. And so I would hope that everybody accepts and supports this amendment, because to me it's just common sense.
Hear, hear.
The question, the honourable member for Elwick.
Thank you. I entirely agree with the member for Mersey and appreciate him putting it so articulately. We've got to remember here that we're debating a bill on which we're being asked to make a significant planning decision to rezone land for which we were provided no criteria for making our decision on rezoning land. We were provided with no assessment other than the proponent's own consultant commissioned assessment. We had no criteria on which to base our decision. Rezoning land is a significant decision, and it still floors me that it appears that this bill could pass based on us making a decision based on being presented with no assessment, no actual criteria for our decision making, and just lines on a map. I mean, it's just beyond my belief. It blows my mind. Local government would never get away with making a rezoning decision based on the information that we have been presented with here today. It's just floors me, absolutely floors me. So the least the government can do is require the university to meet some criteria when coming back to us on these decisions. It's the least the government can do. And again, what's it afraid of here?
Yep.
It's just absolutely beyond belief, and I really hope all honourable members will support this. It's not asking much.
The question is the amendments be agreed to. The Honourable Minister.
Thank you very much, Madam Chair. I think the issue that we have here is about being too prescriptive of the information that the university would need to provide. It is members who hold that ultimate authority here, and if they don't have the information, they're not going to support what's being put forward. So this amendment is detail that's not required until there is an actual proposal, and yeah, the real concern here is about being too prescriptive of the information the university would need.
The question is the amendments be agreed to. The honourable member for Elwick.
I still, if the issue is being too prescriptive, what's the worst thing that can happen with being too prescriptive? What's the problem with being prescriptive? I don't think the government's made the case there other than saying it risks being too prescriptive. It doesn't mean honourable members can't ask for additional information when it comes back to the Parliament, and we might or might not get answers, as we've seen with this particular debate. And look, I still hope given the flaws in the decision-making criteria here and the lack of decision-making criteria, that this bill doesn't pass. But if it does pass, again, this is the least that we can ask for. It doesn't hurt to be prescriptive, the government hasn't explained how it hurts to be prescriptive. It doesn't prohibit honourable members from asking for additional information. It doesn't prohibit the university from providing further information beyond what is prescribed. So I just don't think that argument stacks up.